I request all of you to please stand. Please be seated. A very good morning. We welcome you to this one-day program on Judiciary and the Media, Local and Customary Laws under the 6th Schedule in Meghalaya. We are happy to have with us honorable judges, judicial officers, government officials, heads and faculty members of different educational institutions, judicial officers, advocates, prosecutors, police officers, officers and staff of the registry and the district courts, law students, special guests, and well-wishers. I would now like to invite our dignitaries to the dais, Honorable Mr. Justice Surya Kant, Judge, Supreme Court of India, Honorable Mr. Justice I.P. Mukherjee, Chief Justice, High Court of Meghalaya, Honorable Mr. Justice Pinaki Chandra Ghosh, former Lokpal and retired Judge, Supreme Court of India, Honorable Mr. Justice H.S. Thankyu, Judge, High Court of Meghalaya, Honorable Mr. Justice W. Dingdor, Judge, High Court of Meghalaya, and Shri Amit Kumar, Senior Advocate and Advocate General. Registrar General to kindly lead the dignitaries to the dais. May I request all to stand for the national anthem, which will be led by the members of the Khmer Society.
Janagana mana adhinayak jaya he Bharat bhagya vidhata Punjab Sindh Gujarat Maratha Dravida Utkala Banga Vindhya Himachala Yamuna Ganga Uchchala Jaladhi Taranga Tava Shubha Name Jage Tava Shubha Ashisha Mage Gahe Tava Jaya Gatha Jana Gana Mangala Dayaka Jaya He Bharat Bhagya Vidhata Jaya He Jaya He Jaya He Jaya 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 He.
Please be seated. May I now request the Honorable Mr. Justice Surya Kant to kindly lead the other dignitaries on the dais in lighting of the ceremonial lamp. Me Creative Society is an organization based in Nongstoin, West Khasi Hills District, Meghalaya. It focuses on nurturing talents, skills, and creativity, particularly in the realm of music and cultural preservation. Their creative projects highlight the rich cultural heritage of the Khasi people. Please allow me to invite the members of Khmer Society to present us with a welcome song.
Good morning, everyone. The song that we are going to sing is about honoring our leaders and our forefathers for the contributions they have made, and for us, the younger generations, to follow the footsteps to take our beloved country to greater heights. The song is called Dienjan. Mungkin mau ya Ki, lentir Marta.
Amanuban budin panlam yaki Shakitai, shakitai Kumuklur jompi Amanuban budin panlam yaki Shakitai, shakitai Kumuklur jompi
Din jat ki jong phi
Thank you.
Dinjat, meaning footprints. Thank you for that heartwarming welcome song. It was a delight listening to you. We would now like to call upon our Honorable Chief Justice, Justice I.P. Mukherjee, to deliver the welcome address.
My Lord, Mr. Justice Suryakant, my Lord, Mr. Justice Pinaki Chandra Ghosh, my brothers on the bench, Justices, thank you, Lingdo and Bhattacharjee, learned Advocate General, the members of the registry of this court who have sacrificed their Easter break and their religious obligations during that period to lend such a handsome support to this program. Members of the Judiciary, District Judiciary, Learned Advocate General, and members and officers of the administration, the police, and of course not to forget our Registrar General and Mr. Obijit Ghosh and their team who have contributed so much to making this event a success, ladies and gentlemen, and also members of the families of judges who are here. When my Lord Justice Suryakant was pleased to spare some moments for me in a program in Delhi, I came to understand that His Lordship had not been to Meghalaya. At that point of time, I invited His Lordship to see this beautiful place and also this magnificent court building and bless the institution as well as the state. We are indeed, I am, and all of us are indeed very grateful to have His Lordship's footprints in the court premises. When I was appointed Chief Justice of this court, I was generally told that you go there and appreciate the natural beauty. You have a few months there, and there is a sprawling, magnificent judge's residence, and spend your time there. So the impression I got was it was kind of premature retirement. But when I came here, I came to appreciate more and more with each passing day that this is the best possible posting for a Chief Justice in many ways. The beauty, no doubt, is breathtaking. Natural beauty is breathtaking. The climate, very bracing throughout the year. The cooperation of the honorable judges here, incomparable. The registry officials are 24 hours on duty and very disciplined, very cultured. Members of the district judiciary, likewise. The bar is very strong and very erudite, but the problem with them is they ask for too many adjournments. If they did not, we would be busy in the courts from 10 to 6 o'clock. In fact, by the time I leave court, it is about 7 o'clock. There is so much of work. There is quality litigation, and the public interest litigations which are in this court are very interesting and very constructive. We have public interest litigation for highway repair, for airport extension. The runway, as you know, of this airport is very short and needs to be extended for more aircrafts to land in this place. Controlling dangerous stray dogs on the road, maintaining rule of the road, preventing illegal mining, preventing demolition of heritage buildings, and illegal slaughter, display of animals on the road, this kind of litigation, which is very healthy. And I would like to share this with you and also bring to the notice of my Lord Justice Suryakant that between January and March 2004 and January and March 2025, there has been a 33% increase in the disposal of cases by the division benches of this court. As far as institution is concerned, between January and March 2024 and January and March 2025, in the single bench, there is 30% increase in institution, in civil cases, and 20% in criminal cases. And if you combine division bench and single bench, there is an increase of 25%. As far as pendency is concerned, and where writ is the predominant litigation, 524 are only pending, out of which 230 are of 2024 and 82 of 2024. That is, out of 524, 312 are very recent, of 23 and 24. The rest have been disposed of. So I have a very humble and honest prayer before His Lordship that in view of this, please increase our judges' strength from 4 to at least 5, if not 6. We have the infrastructure for that. And that would also inure to the benefit of the district judiciary, who would have a greater chance of promotion. And I would also request my Lord Justice Suryakant and also Justice Ghosh to consider extending their stay, which is very short, to enjoy the beauty and the hospitality of our people. Thank you very much, and hope you have a very good function.
Your Lordship, thank you for your warm and gracious welcome and for highlighting the achievements of our Honorable High Court. Your Lordship's thoughts and insights on today's program is encouraging. Allow me to mention that His Lordship has been the instrumental force behind today's program, and we are privileged and grateful to His Lordship for setting a very strong and encouraging tone. We are happy to have with us honorable dignitaries and guests in our midst, and we would like to felicitate our dignitaries. I would now like to request our Honorable Chief Justice, Justice I.P. Mukherjee, to felicitate our Honorable Chief Guest, Honorable Justice Suryakant. I would now request the Registrar General, Shri E. Karamnod, to kindly felicitate our Honorable Chief Justice, Justice I.P. Mukherjee. I would now request Srimati Dashlin Karpating, District and Session Judge, East Khasi Hills, to kindly felicitate our Honorable guest, Honorable Justice P.C. Ghosh. I would like to call upon Madam Dapira Sotun to kindly felicitate our Honorable Justice H.S. Thank you. I request Srimati D.G. Karshing, CGM West Jayantha Hills, to felicitate Honorable Justice W. Dingdaw. I request Srimati Basuk Shisha Kharbithai, Secretary DLSA West Jayantha Hills, to please come forward and felicitate our Advocate General, Mr. Amit Kumar. Ms. Tibri Linti Kharkongor, to kindly come forward and felicitate Madam B. Mukherjee. I would call upon Ms. Adeline Thank You to kindly felicitate Honorable Srimati Justice Moshmi Bhattacharya. Srimati Darihun Thaba to kindly come forward and felicitate Madam Debjani Ghosh. Ms. Bandarisha Kharluki to kindly come forward and felicitate our Honorable Justice B. Bhattacharjee, Additional Judge, High Court of Meghalaya. Thank you. I would now like to call upon Shri Amit Kumar, Senior Advocate and Advocate General Meghalaya, to kindly address the gathering.
Honorable Mr. Justice Surikant, Judge Supreme Court of India. Honorable Mr. Justice I.P. Mukherjee, Chief Justice High Court of Meghalaya. Honorable Mr. Justice Pinaki Chandra Ghosh, former Lokpal and former Judge Supreme Court of India. Honorable Ms. Justice Moshmi Bhattacharya, Judge High Court for the State of Telangana. Honorable Mr. Justice H.S. Thank You, Judge High Court of Meghalaya. Honorable Mr. Justice W. Dingdaw, Judge High Court of Meghalaya. Honorable Mr. Justice B. Bhattacharjee, Judge High Court of Meghalaya. Distinguished members of District Judiciary and Registrar General and officials of Registry, esteemed colleague, senior advocates, office bearer of the High Courts and District Bar Associations, members of the bar, and other respected dignitaries, ladies and gentlemen. It is my distinct honor and privilege to welcome you all to this significant gathering where we deliberate on two pillars of our constitutional democracy: judiciary and media, and local and customary laws under the 6th schedule in Meghalaya. We are especially privileged to be joined by Honorable Mr. Justice Surikant, whose powerful words, "The pursuit of justice journey, one that requires our collective dedication and untiring commitment," perfectly capture the essence of today's discourse. Indeed, justice is not responsibility of judiciary alone. It is a shared duty involving the courts, the media, civil society, and above all, the people. Each stakeholder plays a vital role in ensuring that justice is not only delivered, but it is visibly upheld. Though distinct in the functions, the judiciary and the media are both essential instruments of democracy, guardians of public trust and accountability. Their synergy or lack thereof significantly shapes how justice is accessed and perceived by the common citizen. Media bears a unique responsibility to inform with truth, fairness, and objectivity. The rise of legal journalism, platforms like Live Law, Bar and Bench, has brought judicial proceedings closer to the people, demystifying the courtrooms for laypersons. These are not merely news platforms, they are bridges to justice. However, this role must be exercised with utmost care. In an era of social media algorithm and information echo chambers, public perceptions and at times even judicial proceedings can be skewed by sensationalism, misinformation, and trial by media. As Honorable Justice D.Y. Chanchur aptly noted, even judges now must weigh their words more cautiously than ever. To protect the sanctity of justice, we must cultivate mutual respect within media and judiciary. Transparency must never come at the cost of fairness, and journalistic freedom must not transform into adjudication. New age platforms like blogs, OTT channels, and podcasts have redefined how information travels. But this evolution have emerged serious concerns: cyberbullying, privacy breaches, hate speeches, information, and AI-generated deepfakes. Honorable Justice Surikant has highlighted these dangers and urged us to critically evaluate digital content in the fast-changing landscape. Justice must evolve, and so must our judicial infrastructure. Today, I use this platform to draw the attention to a matter of pressing importance: the urgent need to increase the bench strength of the High Court of Meghalaya. Established in the year 2013, Meghalaya High Court currently operates with sanctioned strength of just 4 judges, including the Honorable Chief Justice. This modest number serves an entire state characterized by diverse population and complex legal needs. While the court has performed admirably, the rising case burden has exposed the limits of a skeleton bench. According to National Judicial Data Grid, over 73% of cases in Meghalaya have been pending for more than 1 year. Compare this to the Manipur, a state with a comparable population, Meghalaya 35 lakh, Manipur about 29 lakh, where only 53.85% cases face similar delays. Notably, Manipur has 5 judges, which is more than Meghalaya. Numbers may seem small in absolute terms, especially when compared to states like Uttar Pradesh or Delhi, but in states with limited legal infrastructure, every single judge carries an exponentially higher caseload per capita. This shortage is felt acutely when judges recuse themselves due to potential conflict of interest. With so few judges on the bench, such recusals often lead to prolonged delays, sometimes forcing parties to seek transfer to other high courts. The strength increased, if the strength is increased to at least 5, many of these cases could be retained within Meghalaya. On a lighter note, with an expanded bench, we might even invite transfer from the other high courts to fully utilize our capable bench and bar. A limited bench can also lead to subtle constraint in collegial functioning. When judges sit frequently together, there may be unspoken hesitation in expressing dissent. A larger bench allows for more independent reasoning, healthier judicial debate, and more robust system of checks and balance. Moreover, more judges enable better specialization. Matters can be allocated based on subject, taxation, IPR, commercial dispute, PILs, environment laws, and of course, customary and tribal laws specific to Meghalaya. This leads to better jurisprudence and faster disposal. Geography adds another layer of urgency. Meghalaya's unique terrain, remote villages, difficult transport, and scattered infrastructure makes access to the High Court a formidable task for many. Delays caused by small benches accentuate these hardships. We must therefore consider implementing a nationally accepted minimum benchmark of the number of judges in every high court. Small high courts cannot be allowed to function with skeletal benches that compromise access to justice. I would also like to emphasize the need for a permanent division bench in the Meghalaya High Court, especially for criminal appeals. This is only feasible with sufficient judicial strength. An increased bench will also benefit the subordinate judiciary by opening more promotional avenues, motivating judicial officers, and fostering a strong performance-driven culture throughout the system. As Meghalaya continues to attract entrepreneurs and investors, commercial disputes are also on the rise. A specialized commercial bench would greatly benefit this trend. In this context, I appeal to this esteemed gathering to support the establishment of Regional Arbitration Center in Shillong. With its natural beauty, climate, and strategic proximity to Southeast Asia, Meghalaya is well positioned to become a hub for commercial dispute resolution in the Northeast. As Honorable Justice Suryakant noted, arbitration cases go to London and Singapore. Shillong could be a cost-effective and timely alternative. In conclusion, as we examine the dynamic relationship between the judiciary and media and the distinctive legal fabric of Meghalaya under 6th Schedule, one truth stands firm. Justice must evolve alongside society without compromising on its principle. We must build institutions that are not only efficient and well-equipped, but robust in local realities and driven by public trust. Let's walk away from today's gathering with not just insights, but intent to strengthen our judiciary, not only in numbers, but in vision, specialization, and cultural relevance. As Honorable Supreme Court, as Honorable Justice Suryakant has powerfully reminded us, Indian courts do not just interpret the law as a cold command, but as a living instrument of justice. Let's ensure that law and equity continue walk in hand in hand. Let's open new vistas of jurisprudence for protection of marginalized communities, for women, for victims of violence, and for all who seek justice but fear they may not find it. Justice Suryakant has shown the path many a times to use equity and law in case of right to abortion, protecting the property rights of minor girls, notice in a case of civil revision converted into writ petition to protect and preserve the rights of women, poor section of society, victims of violence. We all should follow the high example set by Honorable Justice Suryakant. As noted by Justice Suryakant, that Indian courts do not interpret, that we have to imbibe and strive to imbibe the above principles in dispensation of justice to poor and marginal sections of society. Thank you once again to your Lordship for coming to Meghalaya and blessing us with gracious presence. Thank you very much.
Thank you, sir, for addressing the audience and for highlighting the need of our Honorable High Court in order to strengthen the judiciary. We are honored to have in our midst Honorable Mr. Justice Pinaki Chandra Ghosh as our guest of honor today. Briefly, His Lordship was appointed as a permanent judge of the Calcutta High Court in 1997 and served as the Chief Justice of the Andhra Pradesh High Court before being elevated to the Supreme Court of India. His Lordship retired from the Supreme Court in 2017 and was later appointed as the first Lokpal of India till the year 2022. His Lordship has also been actively involved in various legal and philanthropic organizations contributing significantly to legal education and services. We are honored to have with us Mr. Justice Pinaki Chandra Ghosh, and I take this privilege to request His Lordship to kindly address this gathering.
The Honorable Mr. Justice Suryakant, the Honorable Judge of the Supreme Court of India, the Honorable the Chief Justice, Justice I.P. Mukherjee, Chief Justice of Meghalaya, Honorable Justice Mausumi Bhattacharjee, Judge of the Telangana High Court, and the Honorable Judges of this Meghalaya Court, and all the members of the judicial fraternity who are present here, the learned Advocate General of this Meghalaya. I express my thanks to the Honorable Chief Justice of Meghalaya High Court and all the Honorable Judges of this Honorable Court and the organizers to give me a chance to come here and be present in the discussion of the today's subject, Judiciary and the Media and Local and Customary Laws under the 6th Schedule in Meghalaya. No topic has been fixed, so far I am concerned. So you can understand that I can play according to my wish in this field at the moment. But I will only start to saying that the media and the judiciary, both are very strong, holdings to keep the democracy of the country to carry on. There must be freedom of press, no doubt, and media, but in order to be deserving freedom, the press must show itself worthy of it. A free press must be a responsible press. The power of the press is great. It must not abuse its power. It's not the sayings of me. It has been specifically stated by Lord Denning in a matter before the Supreme Court of, in UK, in the matter of British Steel Corporation versus Rwanda Television in the year 1981. In fact, he has also stated for the balancing the competing interests, the freedom of speech, as well as the dues or the duties of the press has to be filled on priority basis. No professional would be influenced, he has specifically stated, meaning thereby the professional, either journalist or the professional judge who is deciding the matters sitting on the bench. Why? Because the freedom of speech and the right of the court to decide the matter would not be influenced in any manner whatsoever, either on the ground of the reporting the matters before the public at large, or deciding a matter in the light of the laws and the facts which will be placed before the court. That's the reason it appears that no professional judge would be influenced in the least by any criticism that appeared in the newspaper, even if he read them, or on the television, even if he watched it. That was the idea expressed by Lord Denning in Attorney General versus BBC in the year 1981. I would say, rather, he has also specifically stated that the judiciary, that all judges would ask is that those who criticize us must remember that from the nature of our office, we cannot reply to their criticism. We cannot enter into public controversy, still less into political controversy. We must rely on our conduct itself to be its own vindication, exposed as we are to the winds of critique. Nothing which is said by this person or that nothing which is written by this pen or that will deter us from doing what we believe is right. Nor I would add from saying what the occasion requires, provided that it is pertinent to the matter at hand. Silence is not an option when things are all ill done. So therefore, steps has to be taken by the court in writing of the judgments, expressing themselves in the facts and circumstances of the case, applying the rule of law. We must meet the challenge rather than wish it were not there before us. Media persons would also be required to know aspects of the constitutional law, human rights, protection of life, and liberty of law or law on contempt. These are the things which are specifically stated by our Law Commission of India in their 200, the report which were placed by them before the government. We have also seen, which has been stated, being the preamble to Madrid principle, that freedom of media is an integral part of freedom of expression, which is essential in a democratic society, but it must be also to be kept in mind that governed by the rule of law. It is the obligation on the part of the media to respect the rights of the individuals and the independence of the judiciary. Orders have been passed by the court giving and protecting the rights of media in many cases. I do not want to give all the names of the cases or citing the cases, but it has been specifically stated that there are specific legal provisions which are really regulating the media by rule of law. Criminalizing the disclosure of victims is specifically identified. Censor a publication that lowers the reputation of the person. A principal media, therefore, will take into account of all these things and carry it on. Media has a right to report court proceedings in a fair, accurate, and in responsible manner. Hands of judiciary and media should be strong enough to do their job without fear or favor. I shall be enriched presenting myself here to hear my Lord the Suryakant on this aspect, and I am also sure that the technical sessions will be there, raising many questions which will be discussed, and the points should be emerged by such discussion. Again, I express my gratitude to the organizers for giving me this opportunity to be present here. Thank you all.
Thank you, sir, for addressing this gathering and for touching on the key points on the powers and roles of the press, and by placing reference to Lord Denning's expression on freedom of speech and the court's reaction to it, and also the fair reporting of the media. I once again welcome members of the Khmer Creative Society to give us a special song.
Check. So the name of the second song is called Kathma, meaning a war. In the depths of our hearts and our minds, there's always a battle that rages on. Regardless of our ages, be it fear, doubts, insecurities that tries to consume us every day. So this song is about the battles that we silently fight and the triumph that awaits for those who dare to rise above.
syashkor kat padang timur namin siang benila kabor hakyar ulum marway ngayon kawan sertai mensir kamayan kabling basur ki
Thank you once again for that wonderful rendition of a song perfectly arranged and delivered. We wish Creative Society the very best as it strives to nurture talent, skills, and creativity in pursuit of cultural preservation through music. We are humbled and honored by the presence of Honorable Justice Surya Kant as chief guest in today's program. Briefly, His Lordship began his legal career by practicing law at the District Court, Hisar in 1984, and later moved to Chandigarh in the year 1985 to practice at the Punjab and Haryana High Court. His Lordship was appointed as the youngest Advocate General of Haryana in 2000 and was designated as a senior advocate in 2001. His Lordship was appointed as a permanent judge of the Punjab and Haryana High Court in the year 2004 and later served as the Chief Justice of the Himachal Pradesh High Court from October 2018 until His Lordship's elevation to the Supreme Court of India in May 2019. Honorable Justice Suryakant has delivered significant judgments on human rights, gender justice, education, and prison reforms. It is with distinct pleasure that I would like to invite His Lordship, Honorable Justice Suryakant, to kindly deliver the inaugural address.
Justice I.P. Mukherjee, Honorable the Chief Justice, High Court of Meghalaya, Justice Pinaki Chandra Ghosh, Honorable former Judge, Supreme Court of India, and former Lokpal of India, distinguished better halves of Justice Ghosh and Justice Mukherjee, who have also graced this occasion. My esteemed brother Justices, thank you, and Justice Dingdo on the dais and Justice Bhattacharya of the dais from the High Court of Meghalaya, Justice Mosami Bhattacharya, Honorable Judge from Telangana High Court, Mr. Amit Kumar, Advocate General of Meghalaya, Registrar General, District Judges, and the judicial officers of the state of Meghalaya, learned senior advocates and members of the bar of Meghalaya High Court and the district courts, officers of the civil administration of Meghalaya, the police officers of Meghalaya Police who are present here, distinguished faculty members of the National Law University, Meghalaya, and other law schools, the young artists who have performed with their melodious voice, the honorable family members of the judges of the High Court who too have spared time for this event and are present here. And most importantly, my dear students, ladies and gentlemen, friends from media. A very good morning and namaste to all of you. I must first of all convey my gratitude and thanks to Honorable the Chief Justice of Meghalaya High Court for inviting me. His Lordship must have been a very successful lawyer, as I can guess from the persuasive value which he possesses. I was very keen to visit to this state, but would not have been possible except that Chief Justice Mukherjee really impressed upon me that I must come at the earliest. The picturesque state of Meghalaya, where the clouds descend to the earth and wheel it in an endless drizzle, is something, a unique experience which has mesmerized me since yesterday when I reached here. I am thankful to be a part of this distinguished gathering on this one-day event organized by the High Court of Meghalaya. It's indeed a very laudable step taken by the institution. I think before I advert to the theme which I have chosen to speak before you, there is a very pleasant caveat which has come from Honorable the Chief Justice as well as the learned Advocate General of the state. And I must say a few words in that regard. The first thing which was extremely encouraging and for which I will heartily congratulate Honorable the Chief Justice and his entire team of Honorable Judges and the District Judiciary is the rate of disposal which has immensely increased for last 1 year, as the Honorable Chief Justice pointed out, more than 33%. That shows the unwavering commitment of the Meghalaya Judiciary to provide timely justice to the consumer of justice of this state. You deserve a great applaud for that, and I must convey it to you. The second thing, which Honorable Chief Justice probably took it as a matter of concern, but I will congratulate you for that also. And that is with regard to the alarming increase in filing of civil and criminal cases. When the people start coming to the courts, that is a symbol recognition of the trust and faith in the judicial system. And for that, again, you deserve to be congratulated that people of Meghalaya have chosen your platform for the disposal of their civil or criminal disputes. Well, both these positive, pragmatic, and progressive events or actions or developments call for a suitable increase in the infrastructure. It's a very pleasant situation where the head of the state judiciary, Honorable the Chief Justice, as well as the representative of the state, the learned Advocate General, both are in tandem, and I promise that I will take up this matter. We'll try to do something. When I received a formal invitation, Learned Chief Justice also suggested some topics for me to speak. Then eventually I thought that I should share my views on a very comprehensive issue of the justice system's evolving approach to virtual court appearances and the live streaming of proceedings. There are some very positive impact, positive outcome, but there are some negative incidents and apprehensions. Both things need to be effectively addressed. I have tried to touch upon all those things. I hope that I will, at the earliest, in the minimum time, I will try to finish my the thoughts on this issue. As we know, the integration of technology into legal processes has accelerated at an unprecedented level over the last few decades. In 1991, just less than 35 years back, the Supreme Court introduced for the first time the computers only for the purpose of managing operations such as accounts and payrolls of its staff. In 1997, then technology was further advanced for printing cause lists and court orders through computer systems. over time, digital systems have been integrated into nearly every aspect of judicial process. Now just see the phenomenal progress which we have made. The case management is now handled digitally. Filing and court fee payments are conducted through e-portals. Even service of notice is also affected on the other party via emails. Today, from the very first date of filing of a case till the obtaining of copy of the judgment after it is decided, nearly every step can be now completed through a computer-based system. This includes, of course, virtual appearance before the court, as well as observing the court proceedings online. Both these are very important aspects of the technological advancements which we have introduced in our judicial system. But then sometimes the question arises that why we need online appearances and live streaming. Perhaps the most pressing question is what prompted this wave of transformation? Why was it necessary to standardize virtual court appearances and make court proceedings publicly accessible through live streaming? That's a question. I will come later on that how this question is being asked globally. But the concise answer lies in two fundamental principles. One, accessibility, and the second is transparency. What we do mean by accessibility? To put it very simply, accessibility is the primary advantage of digitizing the court process. Generally, accessibility is widely understood. It is a slight, I would say, misconception rather. It is understood as a lawyer sitting, say for instance in Meghalaya, he would instantly connect to and appear for his client before any court, say in Supreme Court or in a tribunal, in any other part of the country, undoubtedly by allowing the lawyer to appear in their cases online through video conferencing software. The legal profession as well as justice system aims to negate time and financial burdens involving in long distance litigation. It also empowers litigants to engage legal professionals from a broader geographical pool. So for example, in Meghalaya High Court, if you have a matter which has a unique and a kind of altogether different kind of nature of litigation, and you find that the one expert who can handle it is available, may not be within India. So this technological advancement of virtual hearing has now enabled you to engage even services from wherever you want an expert to assist the courts. Even beyond the savings from long distance litigation, online hearings lower the delays in litigative process. As early in 2003, the Law Commission of India in 188th report, while considering the steps need to be taken for improving the speed of dealing with commercial cases, at that time emphasized integration of new technology, including video conferencing, to substantially enhance the efficiency of the courts. The adoption of modern technology into the legal process and the ensuing streamlining of administrative processes was undertaken with the objective of reducing overall costs, which would ultimately benefit litigants and aid in making justice more affordable. On the same line, in 103rd report of the Parliamentary Standing Committee on Personal, Public Grievances, Law and Justice also reinforced and contextualized these benefits. It highlighted how virtual court proceedings enable litigants to overcome locational and economic barriers in their pursuit to justice, thereby promoting the ideals of equal justice to all. And that's our constitutional commitment and guarantee to everyone. This report, of course, came during the COVID-19 pandemic, but the committee acknowledged that the advantages of virtual hearing, particularly in bridging gaps in access to justice, would remain relevant all beyond time of crisis. Now, when we talk of transparency, beyond accessibility, virtual hearings and live streaming of proceedings aim at improving the transparency of the justice system. Let's remember that India has long embraced a tradition of open courts, a principle also enshrined in our Article 145 of the Constitution and embedded in both civil and criminal procedural laws. All of you know that Section 153 capital B of the CPC and Section 366 of BNSS, they provide such a procedure, open court procedure. The Supreme Court has also repeatedly affirmed that open trials and proceedings are the rule and not the exception. The commitment to transparency is rooted in the democratic heritage on which our judicial system is founded. This commitment to transparency is not novel within the Indian judicial tradition. In ancient time also, irrespective of the area, the tradition, the culture, all of you, my friends, will recollect that the panchayats used to deliver justice under the banyan tree in full view of the village community. Historical figures of King Vikramaditya, he held the courts in open in presence of all the public, surrounded by all the subjects. Kautilya, in his book, while crafting a judicial framework, placed great emphasis on accountability and transparency, recognizing them as essential tools in the fight against corruption. The principle of open court was significantly advanced in 2018 when the Supreme Court delivered a judgment in Swapnil Tripathi case, that was in 2018, laying down broad guidelines to facilitate the live streaming of court proceedings. This vision materialized more concretely during the pandemic when video conferencing became the primary mode of conducting hearings. All of you know, when the complete everything was shut down, how the Indian judiciary was able to perform outstandingly only because we were well equipped with the facility of video conferencing. We could provide the virtual hearing platforms to all our in all the high courts and the Supreme Court and most of the district courts also. And first time it happened that now a constitution bench proceedings are broadcast on YouTube channel, which is a public platform. Today, most of the benches of the Supreme Court and many high courts allow public access to proceedings via video conferencing, and the constitution bench hearing continue to be recorded and made available on YouTube. I think most of you must have been watching, and even when after coming to the court, from the court, when sometimes in the late evening for the purpose of correcting our own record, we too watch our proceeding, daytime proceedings on the YouTube where all the recordings are then brought in the public domain. Live streaming of court proceedings not only removes the logical limitations of physical access to courtrooms, but also fulfills the ideal of a truly open court, one where any citizen or resident can log in and witness the justice system in action. Transparency of this nature also brings in accountability among members of the bar by enabling litigants from whatever part of the country or even abroad to easily watch their lawyer arguing the case in court. We empower the litigants to protect themselves against any misdeeds that may be committed by some very small apples, bad apples in the profession. Broadcasting court proceeding also serves as a very powerful educational resource for aspiring lawyers. All the district court lawyers, taluka level lawyers, and sometimes they are not in a position to go and frequently watch proceedings in high courts and Supreme Court. So the virtual hearings, the virtual hearing and video recording and live streaming have really become a big avenue for them to update themselves, to abreast themselves that what's happening in, particularly in the landmark cases, how the arguments are being addressed and how the courts are asking questions, forming opinion, and ultimately delivering their judgments. The Supreme Court for some time now has live streamed and preserved hearings before its constitution benches, proceeding that capture pivotal moments in our legal history and the reasoning behind decisions on question of law that apply in rem. We are preserving those recordings so that in future, for the purpose of posterity, those records can be maintained. These broadcasts not only enhance public access, but also offer valuable insight into courtroom conduct and legal reasoning, serving as a vital learning tool for law students across the country. This also it's become a very powerful tool of education, even for the law schools. The students are sitting, the difference between classroom and courtroom now can be very closely watched by all the students, which is, in my opinion, truly a dream realized by law students across the country who now have the invaluable opportunity to witness constitutional questions being argued and adjudicated in real time. Now, what India has done, and we have progressed, let us see what's happening in some of the surroundings or at the global level. As regard to broadcasting, with respect to the live streaming, many jurisdictions uphold the common law tradition of open courts. Much like in India, the Supreme Court of Canada broadcast its hearing through a regulated media platform, occasionally providing audio proceedings also. The High Court of Australia takes this further by permitting private media houses to install cameras and televise proceedings. In Brazil, the legislature has gone a step beyond, establishing a dedicated television channel to broadcast judicial proceedings and promote public legal education. On the other hand, jurisdictions such as United States, US, and the UK, United Kingdom, have raised concern regarding privacy and the potential for interference with the administration of justice. The UK coverage is often restricted to the judge's final sentencing and remarks to safeguard the anonymity and integrity of witnesses and jurors. Similarly, the Advisory Committee on Criminal Rules of the US Judicial Conference has declined to permit the broadcasting of federal criminal trials, citing similar concerns. The Japan has gone even further. Their Article 215 of the Criminal Procedure Code expressly prohibits photography and recording in criminal cases without the court's permission, with a particular emphasis on protecting the privacy of the parties involved. Now, as regard to virtual courts, the foreign jurisdictions often adopt a markedly different approach in developing and implementing virtual hearing systems. Rather than treating virtual appearances as a mere extension of the physical courtroom, countries like Singapore have tailored them to address specific categories of disputes. For example, smaller civil matters such as employment claims or community disputes are handled entirely online, minimizing the need for in-person appearances. These systems also incorporate features like e-negotiation and e-mediation, all integrated within a cohesive digital platform. Similarly, courts in the United Kingdom have implemented a system enabling police officers to appear before magistrate courts via a direct video link from the police station. Their reports, which is published by Ministry of Justice, says that this initiative has led to greater efficiency and expedited disposal of routine court hearings. When we talk of the India and talk of the global developments which have taken place with regard to the infusion of technology into the justice delivery system, we must acknowledge one thing very clearly, that technology cannot be divorced from law. These developments in India or across the world underscore a clear message. Technology must be embraced as an integral part of legal processes. Its use is no longer a reactive measure prompted by the pandemic, but a necessary step towards emboldening the future of the legal profession and the justice system. My personal view is that technology is an inseparable part of modern life, and we as individuals cannot detach ourselves from this reality, whether we are judges or legal practitioners. The law cannot exist in isolation from the technological shifts shaping our world, just as technology transforms society. It inevitably influences the delivery of justice system within it. It is therefore imperative that we integrate these tools, such as virtual appearances and live broadcasting, into court procedures to harness their benefits, enhanced accessibility, greater efficiency, and improved accountability. But then, everything, particularly every good thing, comes with a price. So what is that price we have started paying, and the price which we really apprehend that we'll have to pay? The experience so far does suggest that the incorporation of digital systems into court appearances has not fully realized the goal of accessibility and transparency that initially justified their adoption. Instead, increasingly, we have seen encounter and instances where technology is being misused, exploited, not to strengthen the process, but to manipulate and benefit from it. First, the leader of the bar, learned advocate general, is there, and must be senior advocates are also here. And some of you must have watched in Supreme Court also some live proceedings, and in different high courts also there are instances. The abuse of leniency in appearing online. The ability to argue cases via video conferencing is, at its core, a leniency extended by the court to lawyers and litigants. It is not intended to replace the inherently physical character of Indian courts, but rather to serve as an extension of the courtroom, complementing, not substituting its traditional form. What we witness, however, is a concerning lack of the same respect and discipline in virtual appearances as is observed in physical courtrooms. On an almost daily basis, lawyers appear before us from a wide range of inappropriate locations. And I'm sharing with you, they start arguing their cases while sitting in their car, on the roadside, court corridors, and virtually anywhere. Disturbingly, there have been reports, including from the high courts, of individuals even appearing from washrooms. There was an instance when a lawyer was smoking while he appeared in court, virtually. There are numerous occasions when litigants and lawyers have appeared online dressed inappropriately. There was a gentleman lawyer who appeared in a jean and t-shirt. There are instances undermining the very dignity of the courtrooms. At times, lawyers resort to deceptive measures, such as using visual filters to concern and to conceal their surroundings or conduct. There is a very interesting case that has happened recently in New York. A court in New York discovered that a litigant had used an AI-generated video to argue the case on his behalf. Closer to routine experience, some lawyers neglect even the basic courtesies required for virtual appearances. They fail to ensure a stable internet connection, a functional camera, or a quiet, respectful environment while addressing the court. These instances reflect a troubling erosion of the long-standing traditions of discipline and respect that underpin court proceedings. For members of the bar in Meghalaya, these things will be very shocking because you are known as one of the most respectful and disciplined bar. But I don't want to name some states where the lawyers are taking this kind of undue advantages. When lawyers and litigants treat virtual appearances casually or worse, when they attempt to mislead the judicial process, they undermine the sanctity of both the courtroom and the justice system itself. The other disadvantage which is happening because of the virtual hearing is accumulation of matters with some senior advocates. This is my concern about the young, bright, talented members of the legal profession throughout the country and on pan-India basis. A direct and concerning consequence of the growing popularity of online appearance is that, contrary to its intended objective, the system is increasingly benefiting only a select group of advocates and senior counsels. Rather than enabling wider participation, we often observe a concentration of briefs in the hands of a few. In some instances, some senior advocates take on matters much more than they can reasonably argue or handle in a single day, reducing the quality of representation and defeating the inclusive purpose of virtual hearings. Ordinarily, the lawyers are very mindful of their professional limitations. They won't accept many cases unless they are sure that they will be handled in a day. After all, every case is a challenge for his professional ability, capability, and recognition. However, with the advantage of video conferencing, there is a growing trend of advocates misusing the flexibility of virtual appearances in pursuit of financial gain. Many leading lawyers now accept excessive number of cases, rely on the convenience of logging in remotely whenever a matter is called. The consequence is diminished effectiveness. Advocates are often distracted, anticipating their next appearance in another court, and are unable to assist the court meaningfully. This is what happening every day in Supreme Court. I am talking Monday to Friday, that this kind of trend has started. I have personally witnessed instances where senior advocates, while physically present just outside the courtroom, choose to appear online, all the while continuing to charge client safety fee. The reason is very obvious. If you come inside, you open the door and come inside, then you can't appear in the other courts. So to avoid that kind of situation and to make sure that they are able to appear in all the courts, I am told there are senior advocates outside the courtroom, sitting in verandas and appearing in different courts. In one mobile you are in Karnataka High Court, with the other mobile you are Meghalaya High Court, the third mobile you are before the Bombay High Court. That is not the object and purpose of virtual hearings or video conferencing. And that is what my concern. That's why I said I have personally witnessed that what's happening. Naturally, I don't want to comment on the fee they charge. However, this practice does raise a significant ethical concern. Are these advocates truly serving the best interest of their clients? Are they in a position to assist the court most efficiently? Are they really completely engrossed and involved in the matter which at a particular moment they are arguing, or something else is also simultaneously going in their mind? Is it possible for a human being to be mentally prepared and arguing simultaneously more than one cases? Is it not going to compromise with the quality of justice? Are these issues we need to really address? This issue, to my mind, should prompt serious introspection within the profession. The very purpose of enabling virtual appearances was to broaden access to courts, particularly for litigants situated in far-flung parts of the country. Yet the misuse of this technology, where a few affluent advocates have effectively gamed the system, has resulted in a concerning contraction of opportunities. The object was that the ordinary rung of lawyers practicing in district courts will also have an opportunity to address the Supreme Court. There are sometimes matters where we need qualitative assistance of the lawyers who have practiced in the district courts. There are issues with regard to cross-examination of a witness, particularly where the legal aid criminal appeals come of those who have been convicted, say, for life. Many times we find that what is the meaning of this question which was asked to the witness in cross-examination, and why so-and-so questions were not asked. So maybe the district court counsel who has conducted that trial is in a better position to assist the court. unfortunately, that wider purpose, that concept which was actually meant to infuse the strength in the judicial system for delivering a quality justice at an affordable price or at all in a cost-free system is also, despite the so many merits and advantages, and despite my firm opinion that the technology is now part and integral part of our system and will continue so, these apprehensions need to be addressed. And maybe the other stakeholders of the system who are very responsible legal community, the lawyers themselves will resolve it. Another misuse of live streaming of proceeding, which I am really concerned, is something which extends beyond virtual appearances. There is another troubling aspect is the manner in which live streaming of court proceedings are being exploited. While the judiciary has made significant strides in promoting transparency by opening courtrooms to the public through live streaming, but please see, some irresponsible individuals have begun to misuse this access for personal gain, undermining the very spirit in which these reforms were introduced. Their modus operandi is unfortunately quite straightforward. Individuals extract snippets and clips from live streamed court proceedings, often isolated remarks made in the courtroom without providing any context or explanation of the circumstances in which they arose. These decontextualized videos are then widely circulated through WhatsApp, messaging platforms, and social media, distorting the public's understanding of the judicial process and undermining the integrity of court proceedings. Every day it's happening. In such instances, the intent behind misusing live stream is unmistakable. Those publishing these clips are not seeking to educate or inform the public about judicial process. Rather, their aim is to generate views and personal profit by sensational presentation of the courtroom moments. The effort is often directed at provoking outrage and steering public sentiment, thereby reducing the solemnity of court proceedings into consumable content for commercial gain. These schemes divert the impact which live streaming of proceedings was intended to have. Our aim must be to generate accountability and transparency in the process. As US Supreme Court judge, and all of you are aware that this is how the virtual hearing, in fact, this statement made way back by Justice Louis Brandeis, that sunlight is the best disinfectant, led to so many the modes of introducing transparency in our system. But then busybodies are intent on misusing the process and are instead playing a game of shadows, hiding behind anonymous usernames and presenting a misconstrued notion of how the justice system of India operates. These so-called news providers often have an axe to grind against the system, and they draw a sadistic pleasure out of victimizing the voiceless judges. The broadcasting of court proceedings, particularly in matters of constitutional significance, has immense value, you must understand. And when analyzed by legal professionals with the intent of fostering legal education and public understanding, it will have an altogether different impact. The faculty is here, the law students are here, members of the bar are here. If you criticize a judgment, if you analyze a judgment, and you bring that criticism or analysis in public domain, it undoubtedly helps in the quality of justice delivery system. It empowers the system, it strengthens our hand. But somebody who has nothing to do with system, who doesn't understand law, who has no legal knowledge of the legal intricacies, when they start commenting based upon one single word picked up from the live streaming, that is a danger to our system. A healthy outcome of judiciary's push for transparency must be welcomed by those who are serious stakeholders, and they must continue to contribute fearlessly, of course, and objectively with the purpose of, I would say, the educating the entire system. No one is expert. No one is can claim that he knows each and every nuances of law. But then the teachers, the professors, the senior advocates, the members of the bar, academicians, and other intellectuals who have contributed, who have done in their life a lot of research and have spent their life in this system, they can really help a lot in doing so. We cannot, however, turn blind eye to profit-driven entities who, despite having no genuine stake in the legal system, engage in conduct that tarnishes the image and reputation of the institution. So the question is, how do we approach these issues forward? My suggestion is, today the intersection of justice and technology is unmistakable, and this relationship will only deepen with time. As a collective, our responsibility is twofold. One, to keep our eye firmly on the objectives that drove the integration of technology into the judicial system. And second, on how it is being adopted, implemented, and at times misused in practice. In this collective endeavor, each of us has a vital role to play. As the judiciary, our task is to thoughtfully integrate new technologies into the existing legal framework, ensuring that they serve the goals of accessibility, efficiency, and transparency. Members of the bar bear an equal responsibility to honor the spirit in which these tools have been introduced. If misused, the system may be compelled to reimpose stricter controls. Reporters and media houses with access to live court broadcasts must reflect carefully on how they represent judicial proceedings in their reporting. Most of the law reporters are so accurate, every day they assist the public at large. I don't want to name a few, but most of them who are there in Supreme Court, they are reporting, they are recording absolutely accurate proceedings. And so timely they bring within the public domain, and people are so helpful, whether in a lawyer practicing in taluka level, a judicial officer working in taluka level, he immediately come to know that how the law of land has further been developed or progressed. So they will carefully continue to represent judicial proceedings in their reporting, and for law students, the task is to embrace technological advancements while internalizing the values of respect and dignity that augment our judicial institutions. In this context, let's all remember the words of Justice Benjamin Cardozo, especially the ring true, when he said, "New times demand new measures and new men in the field of law as elsewhere." These roles become all the more critical when we consider the unprecedented pace at which technology and innovation are evolving today. Just as I said, the introduction of computers in the 1990 offered a simple way to manage cases and type orders. Emerging technologies now, on the other hand, present us with fresh opportunities to reimagine and enhance the future of our justice system. As the guardians of justice, when I say the guardian of justice, I does not mean the judges only. It also includes members of the bar, the faculty of law schools, universities, and law students. It is our duty to protect the law from the misuse and abuse of the next innovations. We cannot let the technology deployed to assist the cause of justice to become the very handmaiden of inequity and injustice. We will not allow the technology to become an unruly horse. I hope I can count on all of you present here to support the justice system as it enters the new chapter of digital technology. I thankful to Honorable the Chief Justice and the High Court of Meghalaya, the staff, the registrar, the judicial officers of the High Court who invited me and gave this opportunity to share my views on this subject. Thank you very much. Jai Hind.
Just two mistakes I made in my address. Justice Moshumi Bhattacharya and the faculty of the university who are here, including Vice Chancellor Dubey, are deemed to have been included. Thank you.
Honorable Justice Suryakant, thank you, Your Lordship, for your valuable insights on optimizing court appearances by harmonizing physical, virtual, and hybrid modes with live streaming restrictions. I would now like to call upon Honorable Justice W. Dingdor to deliver the vote of thanks.
Honorable Mr. Justice Suryakant, Judge of the Supreme Court of India, and the chief guest of this function, our very own Honorable Chief Justice, Justice I.P. Mukherjee, Justice P.C. Ghosh, the former Judge of the Supreme Court of India, and also the former Lokpal, my esteemed colleague, Mrs. Justice H.S. Thank you, and Justice B. Bhattacharya, and also Honorable Justice Moshumi Bhattacharya, Judge, High Court of Telangana, Madam Mukherjee, Madam Ghosh, or learned Advocate General, ladies and gentlemen. When I'm called to propose the vote of thanks, it is always, with apprehension of the fact that the program that we are participating today, whether the means justify the ends. I would say this, after witnessing the overwhelming support, participation, and how the program, has progressed right from the start, I would say personally and on behalf of the Honorable Chief Justice as well as the High Court of Meghalaya, that I am thankful, deeply thankful to each and every one of you who have been part of this program. If I repeat whatever the speakers have, addressed before us, it would be futile, since I believe, as I was sitting here, watching each and every one of us, I have noticed the rapt attention that we have, subjected ourselves while listening to the very, I would say, each and every address having its own importance. The welcome address of our Honorable Chief Justice has, included in it the fact situation of the judiciary in Meghalaya. Justice P.C. Ghosh has touched on the area of judiciary and media, which, as I said, need not be repeated. Mr. Amit Kumar, our AG, has also, lent in his valuable contribution and insight on many subjects, many topics, many points that he has touched on, particularly the state of the judiciary in Meghalaya. But I'm telling you, I am overwhelmed by the address of our chief guest, the Honorable Mr. Justice Suryakant. I am sitting here and I'm being educated. I'm being educated thoroughly in the subject that His Lordship has spoken. It has given us, particularly me, I believe all of us also, an insight, an in-depth, and the comprehensive address or the treatment of the subject that His Lordship has delivered in our midst is really worth pondering. It would be to our advantage to take note of what His Lordship has presented to us and to put it in practice in whatever manner that we are involved with the subject. Thank you, Your Lordship, for your very, very, I would say, poignant address and speech in the midst of this august gathering. As required in a vote of thanks, I am required to thank each and every one of you. If I do that, instead of being the object of appreciation, I would be ridiculed for taking your time. Because the vote of thanks is usually one of the last part of the program where everyone is on the edge of their seat, almost ready to get up. And I believe we have some light refreshment after this, so everyone will be looking forward to it. Nevertheless, I have a list of those I have to thank here, apart from what I have already thanked. I would just try to run through it, and if I forget or leave out some names, please excuse me. After all, to err is human. But again, let me repeat the same, that I am very, very thankful to our able leader and guide, the Honorable Chief Justice of this High Court, without whose initiative this program would not have been, alive as it is today. His Lordship, right from the beginning, has been the mainstay of organizing this program. Thank you, Your Lordship, for your astute stewardship, I would say. There are also many people on the scene, off the scene, who are responsible for making this program a success as it is. Sometimes we say this as just as a lip service. But no, I would say this from the bottom of my heart. I have really felt and I've seen and I've noticed that this program has been a success, and it is just halfway through. It's just halfway through. We are yet to come, and be part of the technical session that will follow. So thank you very much for each and every one of you, the Registrar General and his team, who have spared or left no stone unturned in making this program, manageable as it is. He has dealt with all aspects of the matter, everything, dealt with, and we are what we are, enjoying the fruit of his labor. Thank you very much, Registrar General, and also the members of the Judiciary or judicial officers who are here, judicial officers from District Council courts, members of the Bar, the President of the High Court Bar Association, the Secretary General of the High Court Bar Association. I am also very pleasantly surprised to find even members of the police force being part of us, apart from law students, the Vice Chancellor of the National Law University, Meghalaya, and all those who are present here today. Thank you very much for giving your time, and I will tell you once again that what you have witnessed is worthwhile, and it's worth the stay. Thank you very much.
Thank you, sir. Having come to the end of this inaugural session, may I now request all of us to stand for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
We will now break for light refreshment, but before we leave, we will be having a photo session. So I request all of you to please remain in your seats. The photographer will arrange. I request all the participants to kindly enter the auditorium and settle. A very good afternoon and welcome back to today's program. Now we have entered the second part of the program, which is the technical session. There will be two sessions. The first session will be addressed by the Honorable Justice Moshmi Bhattacharya, and the second session will be addressed by Honorable Mr. Justice H.S. Thank you. So for the first session, the topic is Judiciary and Media. We welcome you, ma'am, to today's program, and we are grateful for your willingness to join us. Briefly, let me mention that Honorable Justice Moshmi Bhattacharya is a distinguished judge currently serving at the High Court for the state of Telangana. Her has completed her schooling at Loreto House, Calcutta, and earned a BA with honours in English from Jadavpur University. She pursued her LLM at the University of Cambridge with a Rotary Ambassadorial Scholarship and was enrolled as an advocate in the year 1997. Her legal practice spanned various courts, including the High Court at Calcutta, the Supreme Court of India, and other specialized tribunals. Honorable Madam Justice Moshmi Bhattacharya was elevated to the bench of the Calcutta High Court in 2017 and later transferred to the Telangana High Court in March 2024. Ma'am, we welcome you and we hand over this time to you.
Good afternoon, Honorable Justice Pinaki Ghosh. One of my most favorite judges from the Calcutta High Court, long acquaintance. My esteemed colleagues, Honorable Justice Thank you, Honorable Justice Dengdo, Honorable Justice Bhattacharya, the Advocate General of the state of Meghalaya. Everyone who's made it their time and worthwhile to come and hear this session, be present, thank you very much. And it is just like a dream place to come and talk about a topic which has become suddenly very important. You heard Honorable Justice Suryakant in the previous inaugural session as to how important media is to the life of a judge, and I am only restricting it to a judge because that's my topic for today. But I realize that it's equally important to all other stakeholders of the justice delivery system, be it advocates, be it the draftsmen, be it solicitors, be it the litigants, and be it the common public who have an interest in hearing what is happening in the field of law. How is the court delivering justice, disseminating justice? So I would look at the topic in this way. On one hand, we have the judiciary, and the other hand, we have the media. The objectivity of media houses, the way they represent court proceedings, the way they represent happenings, proceedings in court, the content of judgments, while they have a responsibility and a right under Article 19(1)(a) of the Constitution, which protects the right to freedom of speech, they also have a counterbalancing responsibility not to sensationalize judgments or not to oversimplify judgments in some cases, because for example, you know that now there is a very pressing issue of national security. We have specialized legislations which provide for in-camera hearing, which prefer maintaining anonymity of the main persons who come before the court. So the media must also be responsible and not expose certain individuals, certain litigants from any kind of unwanted publicity. We also have there's a concept now which is called media framing, quote unquote, where the way a story is presented, the way a court proceeding is presented, the way a judgment is presented to the public is sometimes completely distorted. The judges themselves don't recognize their own judgments. The judges in court, they are projected as performers and not as judges. So these are very risks we have. We also have the way media sometimes portrays the judiciary, not in very happy light all the time, but they pick up isolated incidents of judges making a stray remark, making a random observation in court, and they go on highlighting that with various kinds of highlights, colors, sound aggravations, so that the judge becomes a kind of villain in the eyes of the public. People who don't know the judge, people who don't know that particular court. So there is always this balancing tension, if I may say, between the judiciary and the media. But as the bottom line I would look at it is that judicial integrity must be preserved at all costs, because we know that the separation of powers, the doctrine of separation of powers, makes judiciary completely independent. And if we want to preserve that independence as judges, as judicial officers, then we must also not allow ourselves to be influenced by what the newspapers are writing about us, what somebody is commenting about us, what the Twitterati is saying, what the other forms of social media are saying. And I might say this at this stage, that to us now, to many of you in the audience, media means Instagram, media means Facebook, media means Twitter. But to me, because probably I'm not on any social media except WhatsApp, it's still the newspaper. It is still not so much the radio, but certainly the newspaper, which is the first disseminator of news. I mean, every morning, if I get time, otherwise in the night, that is my source of news. And as judges, I would feel that, and this is my firm view, that you cannot even worry about how the media is portraying you. You just need to be completely, you just have to obliterate that part of your existence, that how is the media looking at me, that should not be at all a point of concern for a judge. The media and the justice delivery system. I have a very short PPT, so it is about 8 slides. I wanted to make it a crisp talk. So how does the judiciary deal with the media? You have the points on the screen in front of you. I will not repeat it. All that I want to say is that, friending as a judge, friending people on social media or following people on social media has its definite risks, because by friending and following, you sometimes, through inadvertence, you give the impression that you are following a cause, or you are sympathizing with a movement, or you even know someone personally who represents a cause. And the situation becomes problematic when that very same movement or somebody from that cause, or it may be a political party, it may be a social justice group, whatever it is, becomes a litigant in your court. So in those cases, you have to be very, very, very clear in your mind as to what you want to do, whether you want to release the matter, whether you want to continue to hear the matter. But the thing is that, we all know about this bias, the apprehension of bias, that it is not that you think that you're unbiased, that you don't have any problem. Bias is all about the person in front of you. What is the perception of that person, that litigant, that lawyer in front of you about you as the judge? So it is completely irrelevant whether I think while hearing a matter that my mind is free. I am completely a very unbiased judge. Not at all relevant. What matters is whether the litigant in my court thinks that I, as the judge sitting in that chair, hearing that matter and to deliver a judgment on that matter, is unbiased. So that is a very, very important consideration, which I think a lot of us, including me, I cannot say us because I am part of that group, tends to forget. That is very important. And online presence, the other factor which has become very important, online presence. If the public or even your larger circle of friends and acquaintances constantly see you as liking, friending, constantly being present online, whether it's on Facebook or Twitter or Instagram, giving remarks, supporting, thumbs up, thumbs down, smileys, whatever the other things are, then that gives an apprehension of bias. And you all know as practicing litigants that it is not actual bias which matters, but any person thinking that this judge may decide a matter in a particular way is enough for you to fall foul of the bias standard. So there should not be any preconceived notion about a judge as to which way the judgment will go. And you may be a good judicial officer, you may be a very hardworking judicial officer, a judge, but ultimately you should not do things, you should be very cautious from engaging with the social media in a way which would give that kind of, which would lend that kind of apprehension. Now I just hope the judicial guidelines, you have that screen. So in April of 2018, I'll give you just a bit of a global, just in 1 minute. The United Nations Office on Drugs and Crime, abbreviation is UNODC, organized an expert group meeting in November of 2018. And during that meeting, there were several judicial and legal experts from various countries in the world who came together to draft a proposal or draft a group of guidelines on judges' use of social media. And during my research for this talk, I saw that apart from the UNODC 2018 draft and the Madrid guidelines, which is slightly later, and of course the Bangalore principles, there is very little global attempt at formulating some sort of a draft guidelines as to how judges should engage with the social media to preserve the integrity and independence of judiciary. So I just found that the UNODC's, the guidelines are quite relevant for all of us here. That is how the judge, I'll just run through those 6 or 7 guidelines, how a judge is identified on the social media. So, whether the judge uses pseudonyms. So instead of saying, Justice Pinaki Chandra Ghosh, if Justice Ghosh uses a pseudonym while he's on Facebook saying hit and run or something like that, or Mr. Quick, or Mr. Witty, to me personally, not a very good idea, because there is always, there are ways of people getting to know who the real person is behind the pseudonym, and making it much more difficult for the concerned judge to actually regulate his or her behavior on social media. Because once people realize that you are trying to hide your identity, and by that hidden identity, you're supporting causes, or you're negativing causes, or you're, expressing your views on certain political movements, certain social groups, then you become much more vulnerable as a judge when you're judging. Even if that particular social group or political party is not before you, people tend to get, and I have seen so many of my counterparts, and I may be guilty of it myself, where judges are identified. Judges are actually categorized in groups that, oh, name a judge, we'll tell you. Which side the judge leans. And I think for the judiciary, that is one of the most dangerous things. Because when a common man comes to the courts, he or she just wants pure and untainted justice. Doesn't want the judge to be identified with a social cause, doesn't want to think that, oh, this is a wrong court. Let me get the matter released from this court and let me put it before some other court, where the judge will be much more clear, which will be unbiased, will not be identified with any social groups. So the UNODC's guidelines are important. So it also went on to say that the content and behavior for judges on social media should definitely be regulated, and judges should not make friendships online. Because, as I said, making friends online is not a good idea. You have friends in real life, you'll be happy with them. Why go into the online domain at all to make friends? Privacy and security. Judge's life should always be private. My very personal opinion is that, if I had my way now, people should not even know how a judge looks. People should not even know how a judge speaks, should not even be familiar with the looks of a judge. And you should be, as a judge, completely indifferent to seeing your name in the newspapers. I mean, there are so many of us, and I keep on saying us because I don't know, I may be guilty of the same thing, that, we get very excited. Oh, my name has come in the newspaper. Look, see, I don't know what, we call up people to say, the newspapers has reported my particular judgment. It is absolutely, let me tell you, it is absolutely not necessary. The only work of a judge is just to go, sit on that chair, hear cases, deliver judgments on time, try to deliver good judgments to the best of your ability. Don't worry about whether your judgments are going to be set aside or interfered with by the Supreme Court or by the High Court. That's not your worry. Your functus officio as soon as you sign that judgment. So stop worrying about the fate of your judgment. You have given the judgment to your best of your ability, with honesty, with conscience, and with the knowledge of law. That is all that matters. You don't need to care about how the media is looking at you, how the media perceives you as a judge. That is not part of your job. So basically, my view is being anonymous, but of course now times are changing. The world is changing around us, so I may be kind of, a very old-fashioned mindset, because now I find that it's probably desirable that you are projected in media, or that people get to know who you are and what kind of work you are doing. But I must say that, the old values always hold good. Do your work, go back home. That's all that you're asked to do. Don't worry about how you're going to project yourself on any kind of media. So we next have the Bangalore principles. All of you are aware of that. The Bangalore values, that's how they are described. And there are 6 values under the Bangalore principles. And those were formulated by the Bangalore Judicial Group meeting in 2002. We are now in 2025. But I feel that as we are going on and as the years are going behind us, these 6 values are becoming even more important to us now than any other time before. So they are, of course, value 1 is independence, value 2 is impartiality, value 3 is integrity, 4 is propriety, 5 is equality, and 6 is competence and diligence. So that kind of sums up these 6 values as the ideal person sitting on that chair. I don't want to go on saying judge, judge, judge. It kind of, I myself am very uncomfortable personally with, this judge thing, because it inflates, it gives you more importance than you probably deserve. So it is just a person occupying a chair. That chair is never about the power. It's always about responsibility, and it's always about compassion. And it's also about how much law you know and you're willing to implement in your judgments. And of course, giving a fair hearing to everyone in front of you. And competence, diligence, of course, you can't do without those values. Bangalore principle, I've just, this is a slide which I wanted to talk to you about. So the next slide is probably one of my favorite topics. I've kind of spoken about this in quite a few places. That is, yes, how should judges deal with social media? And I'll tell you that in a Wisconsin court in the US, there was one judge. There are many cases in my course of research. There was one judge who was hearing a paternity claim. And in Wisconsin, he was hearing the parties, and he suddenly saw a social media post on Facebook by the mother of the child, whose fate was to be decided by that judge. And that judge liked and friended the mother. And the Supreme Court actually, US, said that that judge is disqualified from hearing the case. So you must step back and give that case to somebody else. Interestingly enough, this was Wisconsin. In Florida, same US, but just see how views are subjective and differ from case to case. In Florida, US, a judge hearing a matter became very friendly with the attorney arguing a particular case before that judge. And the litigants actually complained and said that, what is going on? Why is the judge, friending and liking, and in that case had liked one post of that attorney 3 times, the judge. And the public raised an outcry. And the Supreme Court said that, it's all right, not to worry about. It's not such a great problem. So it's fine. I mean, why can a judge not be friends on social media with the attorney? So the Supreme Court said it's fine, not a problem. So when you come to this particular screen, how should judges behave in the social media? I won't kind of go on about it because I've more or less covered that topic, basically to not only be anonymous, but also to be knowledgeable about social media. Now, if I say that because I'm not on social media except WhatsApp, so I will be a social media illiterate, that's also not a very great thing to say. I mean, I shouldn't be proud of my social media illiteracy. I should at least be aware. What is Instagram? What is Facebook? What is a wall on Facebook? What is Twitter? How is to Twitter, how are tweets important? Does it affect my work as a judge? Am I getting to know some information from the Twitter feeds, from the tweets given by others? So it's not that I should be in the dark and say, no, I'm very fine, I'm not on social media, so I'm a very good judge. Not at all. I should absolutely be aware of what's going on around me and move with the times, but make a choice as a judge, as a judicial officer, as to how much you want to engage with social media. Freedom of media. Now, this talk on judiciary and media would not be complete without a small mention, important mention of the Contempt of Courts Act 1971. Many of us actually overlook, we are all aware of the Contempt of Courts Act, and but we are only aware of, when somebody files a contempt case before us, and probably aware of Section 20 as to the limitation of contempt. But we should also be aware that under Section 2C of the Contempt of Courts Act, which defines what is a criminal contempt, so the criminal contempt has three limbs. One is any kind of conduct which, number 1, scandalizes or lowers the authority of the court. Number 2, prejudices or interferes with judicial proceedings. And number 3, interferes with or obstructs the administration of justice. So this contempt of court is a powerful tool, I would say, in the hands of a judge or a judicial officer, where you see that the media has overstepped its limits, whether in reporting a court case, a court proceeding, or in interpreting a judgment which the court has given. But apart from being aware of this powerful tool under Section 2C, criminal contempt, you should also be aware that under Section 3, 4, 5 and 7, these are the important provisions, what is not a contempt. So you can't say, send him to prison, send her to prison, sequestration of property. You can't say that, because you are very excited or, you get suddenly very, very excited about the power you have. No. So what are the limits to that power? What is not contempt? So under Section 3, a person will not be guilty of contempt if they publish something that may interfere with a judicial proceeding, but the person did not know that that proceeding was a pending proceeding, a pending ongoing proceeding. I think in the 246th, in a Law Commission report in 2006, the year is correct, but which report I may have forgotten, Parliament actually, the Law Commission actually made a draft amendment to the word pending to be changed to active. But that, now we are in 2025, that was a 2006 amendment. I read about this somewhere quite some time back. But that did not ultimately materialize, but that was an important draft resolution, amendment to Section 2C. And under Section 3 also, again, a person will not be guilty of contempt if they distributed a publication containing potentially prejudicial information without knowing that the content would harm or would prejudice ongoing court proceedings. Section 4, fair and accurate report of judicial proceedings are not contempt. So if it's a fair and accurate report of what happened in court, that person you cannot hold guilty as contempt. So you will have to assess how much overstepping has happened in that area. Section 5 of the Contempt of Courts Act. Fair criticism is not contempt. Fair criticism of judicial acts is not contempt. Section 7, publication of information relating to proceedings in chambers or in camera, not contempt. There are exceptions. So you will, and I have limited time, but if you care to check, it's an old decision of the Supreme Court in 1950, Ramesh Thapar versus State of Madras, where the Supreme Court actually struck down a ban on the entry and circulation of the journal Crossroads under the Madras Maintenance of Public Order Act 1949. And the Supreme Court held that the fundamental right to freedom of speech and expression includes the right to circulate ideas. Very powerful judgment. Then you again have 1972, that case was Bennett Coleman. Bennett Coleman versus Union of India, 1972, 2 SCC 788, Justice Ghosh may correct me on the pages. There again, the act introduced that a newspaper must have only a certain number of pages, not more than that. So limiting the number of pages of a newspaper, and the Supreme Court said that this limiting of number of pages of a newspaper is in violation of Section 19(1)(a). Just see how powerful these decisions are. And of course, there are many other cases. I don't want to go on with them. I'll quickly run you through the... So freedom from media. So when we say freedom from media, what do we mean? What we mean is the risk of media trial. What we mean is, as litigants, as courts, we all become sufferers of a media trial. And what are the key concerns under this area? Of course, the right of privacy, the threat of invasion of privacy. So if I am an unwed mother and I come to the court to seek justice, or whether in terms of my property rights, or whether in terms of keeping my child, or whether in terms of keeping my relationship with my partner a secret, private, from the eyes of the world, I will not like it If the media suddenly comes up and mentions me by name and says so-and-so, this court passed this very important judgment in so-and-so matter, and this is the name of the woman who came and she's in a secret relationship and all of that. So that's a real risk. Invasion of privacy. Next, misinformation overload. You don't know when the media is actually reporting correct events. And I remember reading a quote somewhere that if you don't read newspapers, you are uninformed. If you read newspapers, you are misinformed. So it's like a choice which you have to make. Then public shaming and vilification. There are so many instances where we have seen that so-and-so has been, the court proceeding or the judgment is being reported as so-and-so has said these things against the government. And these things are completely, banned, and comes within the restrictive and special statutes which we have now. And this person is actually illiterate, but has been taken in by this particular political party or social group, or is guilty of corruption. So without correct fact-checking, many cases are reported where there is misinformation overload. Then, of course, public shaming and vilification, assassination of character, and the last is digital addiction. So, as judges, most of us don't have probably time at the end of the day to go on any social media or even sometimes read newspapers, daily reportings. But you find that the times are becoming such that we are becoming unconscious addicts to digital media, where, just for a time pass, just for being entertained, where we are in a room, instead of reading a book, instead of, all the older things which we used to do, I still do it, instead of reading a book, instead of watching news or even a good movie on TV, what we do is we just quickly, it's like instant coffee, instant entertainment. We just open our mobiles and we just switch through saying, okay, so this celebrity, it's now a celebrity culture all around. People are not interested in people who have not made it in life. People are only following and interested in people who are celebrities, who have lots of money, who are wearing nice clothes. So that is our constant feed, media, digital addiction. So I think it's time when we should actually step back and see that what really matters in life as judges. Are we going to constantly look at media for our entertainment? Gag orders, what I propose to do is, this is my third last topic, quickly give you snippets of the important aspects of the tension between judiciary and the media. And in gag orders, what are gag orders? So when a matter comes to the court restricts a party from reporting that particular court proceeding or that judgment, restricts a media house, or sometimes asks a media house or an online platform to take down certain content which the court feels will be harmful or may prejudice the court procedure or may prejudice the way the court, the justice or the case should progress and culminate in a judgment. So gag orders are powerful tools, I would say, where the court actually says that this matter deserves a gag order and you gag somebody. In a very recent case, Justice Suryakant was here, in Ranveer Alabadia's case, for example, who was a social media person and made certain comments, made certain online content, which everyone found offensive, and the Supreme Court said that, very well, don't arrest him, but we will put strictures on him. So no more such shows on social media, or he will not project, or he will not say these things, etc. In Mohammed Zubair, the Supreme Court took a different view, said that no, even though the content or Mohammed Zubair tweets were may incite violence, may cause unrest, but we have the constitutional guarantee of freedom of speech and expression, so we will not issue a gag order. In the Republic TV Arnab Goswami's case, there the Supreme Court, because Arnab Goswami was going on writing reports on how a leader of a political party may have murdered his wife. And the Supreme Court, the Delhi High Court in that case, the Delhi High Court said that, look, until and unless the criminal case is proved against him, don't write any such articles, because what you're doing is that your articles may influence the court, because the criminal case is proceeding and it's pending. So why are you writing these articles? So the next, so these are gag orders, of course. And yes, in gag orders, I must tell you, even though I've gone to the next slide, I read about an English case of very recent, actually, not too old, 2021. Angela Wrightson, a vulnerable adult in the outskirts of London, she was murdered by 2 teenage girls. One was 11 years old, the other was 13 years old. And while she was being tortured, while Angela Wrightson was being tortured and murdered, the entire thing was recorded by those 2 girls and circulated on Snapchat. So that incident became known as the Snapchat murders. But the US court, what they did was the UK court invoked the Venables jurisdiction, which actually granted lifelong anonymity to these 2 girls, because the UK court came to the conclusion that if we disclose their identities, because they had filmed that murder, how they were torturing and murdered this old woman, then their lives may be at risk. So lifelong anonymity given to those girls. And they also, the court felt, the UK court felt that the girls were in a certain mental condition which can lead to self-harm. So lifelong anonymities. I just remembered that case. I thought it was quite interesting. So, so this last slide is not really important for my talk, so I will actually skip it, and and also because Justice Suryakant has spoken about, new media and new technology, AI, not really relevant. But I just want to tell you that there are so many cases which I came across, and I'll just quickly I'll take 2 minutes because I can't leave without telling you what these cases are. So in social media, recently in 2025, Justice Nagaratna, heading a Supreme Court bench with Justice Singh, K.N. Singh, there were 2 judicial officers from Madhya Pradesh, and both their services had been terminated by the particular High Court. And the Supreme Court set aside the termination, saying that the reason given for termination, there were 2, Sarita Chaudhary and some Aditi Sharma, I think. In Sarita Chaudhary's case, she had been terminated because of unsatisfactory performance as a judicial officer. And the other judicial officer had posted something on Facebook which said that, we have such a hard life, so much of work, too much of supervision, etc. And the concerned trial court and then the High Court found the social media post to be offensive and denigrating, lowering the dignity of the judiciary. The Supreme Court said no. First of all, the punishment of the discontinuation of service is disproportionate to the offense. That is, because you have posted something on social media, on Facebook, complaining about your work and your work situation, cannot lead to taking away somebody's job. But the Supreme Court also said, and it kind of disturbed me because I thought that am I doing the right thing, that for judges, quote unquote, live like a hermit, work like a horse. So I don't know how easy it is for us to lead such a life, but this is a recent case, so I thought I'll let you know. Then in Nilesh Navlakha, all the Sushant Singh Rajput murder. So the Bombay High Court, Division Bench of the Bombay High Court, said that the way the social media projected Sushant Singh Rajput's girlfriend in that case, that, she's guilty and she's the one who actually led him to commit suicide, or maybe it's a case of murder. The Bombay High Court said that this is a case where the social media has absolutely overstepped its limits. Then you all know Nupur Talwar's case, where first it was that the parents were innocent, then it came out that the parents had actually murdered Nupur Talwar because it was an honor killing, then again the parents were acquitted. So this entire thing, the media story, and even I read it, I am guilty of it. I used to read Nupur Talwar's whatever came out in the newspapers with great, with great interest and enthusiasm. And then, so this just shows you then Aryan Shah Rukh Khan, when Shah Rukh Khan's son was arrested on that narcotics charge and later on acquitted because there was apparently no evidence against him. Can you recall the kind of media coverage which was thrown at all of us, and we kind of happily lapped it up? We thought that, oh, this is very interesting. Shah Rukh Khan, Nupur Talwar, Sushant Singh Rajput, celebrities, actors, all the time we are following them. So how interesting it is. But the truth remains that not only as judges, but as common people, as the public, as consumers, we also have a responsibility not to give too much importance to how judicial proceedings, court proceedings, and judgments are interpreted by the media. And I'll just end with one thought, which is a closely held thought. It's something which I often think about, that live streaming is now a part of our lives. It's a very necessary part of our lives, and particularly became very, very necessary during the pandemic because people needed access, and as you heard in the inaugural session, not only access, but transparency. So a common man, even if he or she is not a litigant, has a right to see whether the courts are working well. But what live streaming has also done is made judges as performers. I have seen so many YouTube coverage where, the way the judge, instead of looking at the litigants, looking at the screen, and you can make that out. It is something which is funny to me, but actually it's quite serious when I see judges looking at the screen all the time. But we should remember that as judges, as judicial officers, you forget. You just blank out that screen from your mind. You just look at the litigant, the lawyer in front of you, look at the material in front of you, the fact, the law, and you decide. So don't worry about becoming performers. Don't worry about becoming YouTube stars. I remember I was coming back to Calcutta. I was then in Calcutta from somewhere, and there were other judges sitting in the lounge, and 3-4 judges walked in. Of course, I will not give you their names. And the judges who were sitting next to me, they told me, YouTube star, YouTube star, YouTube star. And I was actually quite shocked that, because I don't see YouTube so often, so I was not aware, but that judges can also be identified as YouTube stars. So, can you imagine where we are headed? Because media has become such a powerful weapon that, and it's a fundamental human feeling. I don't know. Maybe I will also be happy if I constantly see my name in the newspapers, or I don't know. I may be happy. It may make me happy. But just as a word of caution, your work is to be low profile in a good way, to be anonymous, come to the court, do your work, whatever admin work you have, also you do, and you go back home. That's the life of a judge. It's a good life. You don't need to worry about media and the way the media is portraying you. Thank you very much.
Thank you, ma'am, for your wonderful presentation on media and the judiciary, which was informative and filled with practical and factual pictures. Ma'am, if some of the participants would like to ask any questions, will that be fine? Or should we wait that till the end of the... So we'll... Okay. We will now come to the second session on the customary laws. We have with us Honorable Justice H.S. Thank you. His Lordship needs no further introduction. But when it comes to this topic on customary laws, we can think of no better person but His Lordship to address this area. So, sir, I hand over this to you.
Thank you. Good afternoon to everyone. Honorable Justice Pinaki Ghosh, my brother judges, Justice Moshumi Bhattacharya from Telangana High Court, the Advocate General, Additional Advocate Generals, everyone present here from judicial officers, police, students, and from all jurisdictions, you can say. Well, I'm looking at district council officers are here also, which is very good. Now, actually, before I begin, I must say this topic, in fact, was asked by the Honorable Chief Justice. He told me that since we're having this program, so it would be good if you would speak on this. So I said, all right, because I think it's very boring for most people, unless you are really a follower of the sixth schedule or you're interested in it. And after the scintillating presentation you had just now, this will seem like, really cold water on the entire session. Anyway, the topic is, I think, codification and its effects, and also the local laws and customary laws that we have. Now you see one thing, we all from here. We all know that we have these oral traditions. We're all part of an oral culture. And we didn't have a script recently. So this oral tradition, this oral culture that we follow, now how do we translate it into everyday legislation? And how will it serve the society? Oral tradition and culture is prevailing. It's good. And though great for oral traditions, it's not good for legal certainty. So if we have to rely on oral traditions and oral culture, then especially for all of you, mostly you are here, we who are in the judicial system, it's not good for legal certainty. So there's a need for codification, writing down these customs to give them the formal recognition. Now, we come to the sixth schedule. Now, what is the sixth schedule? The sixth schedule was made with two objectives. One is to grant recognition to the laws and customary practices of tribal people in as well as Assam in these areas. And secondly, which is maybe not known, is to help in assimilation of these cultures into the mainstream. And what does the sixth schedule have? The sixth schedule is a mini constitution. It's a mini constitution in view of the fact that the district councils which are constituted under the district council have been vested with all the three arms, that is legislative, executive, and judicial powers. And so the coming sixth schedule, it was put in the Constitution, came into being in 1950. And district councils came under the sixth schedule as a means of self-governance at the grassroots level. So, as a mode of self-governance, and in Meghalaya, customary law being integral to the system, the sixth schedule became a vehicle to codify, regulate the customs. Now, what is customs? You all know very well what is custom. I just refer to certain definitions of what is custom. Now, they say custom. I'm sorry I don't have a PPT today because, in fact, I was made in a hurry. So anyway, what's the meaning of custom? The word custom grammatically means tradition, practice, usage, observance, convention, procedure, ceremony, ritual, then formality, manner, all these things, they're custom. But what it generally means is, it means a usage or a practice common to many or to a particular place or class of people or inhabitants of a certain area. And it is a long established practice considered as unwritten law. And also it means a repeated practice. So custom is the whole body of usages, practices, conventions that regulate social life. And one of the hallmarks of customs is that it has to be a long established practice, which is a society recognizes, acknowledges as unwritten law. And so many thinkers have defined custom, like Austin, Salmon. So Salmon says, custom is an embodiment of those principles which have commended themselves to the national conscience as principles of justice and public utility. So Austin has said, customs rule of conduct, which is governed spontaneously and not in pursuance to a law set by a political superior. Article 13 of the Constitution defines also custom as a law. And in the Sabarimala case, the ex-Chief Justice of India, Justice Chandrachud, has said, custom usages and personal law are part of laws in force in Article 13, and hence must comply with constitutional morality and Part 3 of the Constitution to retain legitimacy and legal force. Now it comes to that part with regard to the importance of codification as not be derogatory. There has to be in conformity with the constitutional values. Now, under the 6th schedule, the codification of customary law is not just a technical legal step. As you have seen, I'll come to it a bit later, I'll just touch upon a few legislations where customs codified into local laws. And it is not just a technical legal step taken, but it's a cultural imperative. In fact, it's a political necessity. And legal codification is important. Why? Like I remarked earlier, it gives legal certainty, stability, clarity, and standardization. Without this standardization of customary laws, it ensures stability, clarity, legal certainty, and this codification of a particular customary law helps in the uniform application in all sections of society. So you can say we don't need to do, legal guesswork as to which customs applicable or how we can apply the custom. So, in fact, codification gives customary practices a legal armor. Maybe the passage of time, customs get, as maybe in the passage of time, customs get trampled or they get changed, and in the name of development and integration. Now, another important aspect of codification is what? It helps in cultural preservation. As by codification, a certain practice or cultural practice is preserved in a tangible form and ensures cultural continuity. Now you see in different Rajs, like the areas or ilakas of the Kasils now, certain customs have been inserted also into the particular little piece of legislation that have been made. Now, in those areas, you can say in Garo Hills, they have Social Validating Act. In Jaintia Hills, they have Vaishnong Act, as how, these traditional heads are. Now, those things, the codification of those systems of election practice, of of the manner of function, that helps in the preservation. And once a custom is codified, it gives that judicial recognition. So it enables, once it's codified, it enables the better integration of customary laws with the traditional legal system. So these are just touching upon what is codification and why it is necessary. Now, coming to the function of the District Council, because it plays a very important part in this entire exercise of, custom and codification. Now, you all know that District Council does not have the plenary power of legislation. That means they cannot legislate on any topic. And where they can legislate upon, the subjects are given and enumerated in paragraph 3. So they are empowered to legislate on these specific subjects, provided, of course, these laws must conform to Part 3 of the Constitution. So a very celebrated case, this is the Iwalanki Rambai case, with Jayanti Hills Council. I think most of you will be aware, where the Supreme Court outlined 4 essential criteria for valid custom. Firstly, it must be since time immemorial. Secondly, it must be reasonable. Thirdly, it must have continued without interruption, since its immemorial origin. And fourthly, it must be certain respect of its nature, as when respect of locality which is alleged to obtain and persons whom it is alleged to affect. So that is custom. And what is the duty of the District Council is that under Para 3, they are empowered. They have legislative competence on appointment of chief succession of headmen. That means to regulate the traditional institutions, inheritance of property, marriage and divorce, and social customs. Now, apart from that also, then they have the management of non-reserve forests, use of canals and watercourses, establishment of village-town committees, village-town administration. So these are the things which the District Council is empowered with, and that is in line with the intent of the Constitution in incorporating the 6th schedule, that this mini Constitution has been, brought for the people of this region so that their cultural autonomy, their cultural identity will be preserved, and the unique customs that exist because the minuscule population will be respected, and how to bring it in tune with the modern days, as is not in derogation to Part 3. So you can see that how has this codification happened in recognition before judicial forums and in day-to-day interactions. Now you see the Khasi land tenure system, or the tenure system in Jayanti, I'll just give an example of Khasi Jayanti Hills, where we have re-right community lands and vacant private lands. And nowadays, there have been significant changes with the use of land and management. So, in fact, I would like to share here why does the council have plenary power legislation. In 1953, they enacted an act with regard to land transfer. That was struck down because the Supreme Court said that you don't have the power to extract land revenue. You don't have the power to determine transfer. You only have the power for the use and enjoyment of land. And in the forest acts that have come also, the different types of forests have been noted, they've been recorded, and forest management acts are in place also. These forest management acts also are codifying the practice and the types of forests that we have. And so you all be familiar, like what is Lao Adong, what is, so on and so forth. So that way that there is some certainty that when someone's dealing with this particular, so you don't have to grow up here and there, so how it's defined is defined there. And all this is derived from the custom which is prevalent. So forest management, and then especially the rights of the tribals over the land. Now, forest management is a touchy topic because after the 1996 ban, Forest Conservation Act, so on and so forth, these things happen, then the acts of the state and central government are supreme. So, but the City Council still has the acts which are in place, which is still applied till today. Now, if you all recall, there was a celebrated case from here, which is to do with State of Meghalaya versus All Dimasa Students Union. Now, in State of Dimasa versus, State of Meghalaya versus All Dimasa Students Union, which is taken to the Supreme Court, what was the narrative that was given? And what was the decision? Now, this case is very important because it gave legal recognition of these traditional land systems which have been practiced. And by this judgment, it recognized the right of the tribals to the matters under the soil. And also, it recognized what is defined as what is the community lands, what are private lands. And so, this underscores the entire, you can say, landscape of protection that's been afforded in the 6th schedule, codification has happened, and how this is recognized by judicial interpretation and made stronger. Another case is with regard to Lafarge mining. In this case also, the Supreme Court validated limestone mining in Meghalaya's forest areas, recognizing the traditional practice in Northrai village. And in this case, which was very bitterly contested, the court upheld the environmental clearance and noted the District Council's approval given to Lafarge under the 1958 Forest Act. So what has happened here with codification, 58 Forest Act, Management Forest Act came, the NOC is given on that. The Supreme Court recognized this aspect also. So this is the big plus points of codification. Suppose there was no codification. Suppose there was no codification, we stand in front of a court of law, trying to grab this authority, that authority, to prove your case. So what happens? Suppose you come from a particular village which practices a certain custom, which has not been codified. So judicial interpretation also has come a long way, as also these acts that have come since then. So like I had mentioned earlier, so under this large, so all the definitions of forests have been given, and now they are followed. Then we come to, when it comes to day-to-day thing, the village administration. Village administration also, now the one act, of course, a bill that is pending, but with regard to recognition of ilakas, recognition of traditional boundaries, we have the Ilaka Act, and also the most important thing, which I would say to my mind is the enactment of when it deals with these traditional institutions, the United Khasi Jaintia Hills Appointment Succession of Chiefs Head Act 1959. Now, if you go back in history, you'll know that when the British came, they did not entirely conquer these hills. There were 25 steamships at a point of time, and they were allowed to function as semi-independent entities, subject to under the supervision of a political officer. So these entities continued in the administration of their respective ilakas, steamships, sardarships, so on and so forth. So this act, although it's a uniform and all-encompassing act, then regulated the custom in a uniform manner as what is the role of the council as a supervisory authority in controlling or in regulating and standardization of the appointment of chiefs and headmen in accordance with the general customary practice that was prevailing. Now you've seen, I think you all know, certain acts have come. Suppose for Nongstoin steamship, which electoral college, it comes to Nongkhlaw. So all these things have come now, the acts have become more micro. But 59 Act was upheld by the Supreme Court also in the case of Tikaji with regard to the Pastor's Council and the status of its aim. That also by judicial interpretation. So all these constitutional validity of this act has been tested and it has passed the test. And every day, I say in my court, my brother's courts, we are dealing with these matters. Suspension of chief headman. Many lawyers here are practicing that. It's a very fertile piece of area of litigation. And so, this is what codification has done. Now, as I was saying, village administration, the bill is still awaiting finalization. And the other aspects of how the sixth schedule has contributed towards, bringing a sort of order, much more to be done. How it's contributed to bring about some certainty, some uniformity, some, predictability with regard to adoption of, suppose village administration or even in, like I said again, Garo Hills, Social Validation Act. And there's one part, this is what happened before 59 Act, but I think I will not have time to go into that because that's a very interesting part, and it actually is quite a vast topic, and to go into that is pre-59, pre-constitution, pre-59, after 59, there's a series of cases which are very interesting. In fact, I just noted them down, and I thought if I had time I would share them, but maybe I'll share them some other time. So, 59 Act, what it has done is that it strikes a delicate balance between electoral procedures while respecting Khasi customary laws, vested authority in the council, and limited executive interference. So what does it do? The Act and these other acts, it preserves the aimship's traditional character while integrating it into India's constitutional framework. So that is one thing that's been achieved by these acts which pass the test. And so when it comes to boundary disputes, well, now you have an act for that, so on and so forth. Now, for coming to the judicial aspect, now we have district council courts and all the district councils. Now, what is the role? It's given in para 4 and 5. Now, cases have emanated from there, which have, brought up serious questions of custom and interpretation. And these courts now another very important act, which I should mention, is the Social Lineage Act. Now, that act isn't being used now. It was amended again, I think, in 2007. But that act now has become a very important act because it strikes at the root, suppose who is a tribal or who is a Khasi, and that will come of interpretation. And rights and competing rights that come under the act. So, that is dealing with social customs, the Social Lineage Act. And especially we have to remember that codification here also, we have to remember the traditional Khasi and in the higher state, we follow a matrilineal system of descent. And so this aspect is so important to preserve because we're not patrilineal like other parts of the country. And so how the identity of a Khasi is determined or of Garo is primarily through mother's lineage. And so the coming of such acts, it should be improved. But then the coming of such acts sort of has cemented that position and cemented that custom. Of course, it has other requirements of the act for registration, so on and so forth. And then it gives the, to codifying another custom of, suppose a Khasi male marries a non-tribal female, where they have the ceremony, so that they are not without a clan. It's called a Tangjaj ceremony. Then who can be considered to be a tribal by way of life or so on and so forth. So these are the few aspects which, since the inception of the sixth schedule and continuing now for 70 years, I think, 75 years, how things have crystallized to a large extent. But then, like they always say, there are also demerits also to codification. So does that mean, but it should not mean that they say that once you codify a custom, there's loss of flexibility. I mean, laws become rigid, once codified and cannot change with the needs of the community or the social norms. And in Meghalaya especially, just a note of caution is that in a male-dominated legislature or a rule-making body that codify law, many customs now are there which will not be good law or very attractive or very palatable nowadays, especially in the age of gender justice. And so how traditional institutions are organized, what elections, what is the darbar, you all know that. And there are elements of gender bias because that was the custom prevalent at that point of time. And now there is a need to change. So the evolution of this entire process, though much more needs to be done in the area of codification and development of local laws, they have to be integrated with the constitutional framework. The sixth schedule, it serves as a vital framework, which is given by the Constitution, engraved in the Constitution of India, specifically for these areas. So codification, therefore, should be, in my conclusion is, write without erasing, preserve without freezing, while integrating them within India's constitutional framework. Thank you very much.
Thank you, sir. So as expressed in the schedule, there will be a discussion for those who want to say something. Any one of you would like to express anything? Can just give the mic to...
Good afternoon, everybody. Both the sessions were so full of insight and so much layers attached to it that first time as a lawyer, when you argue in a court, we take a stand, but here it was very riveting, very knowledgeable, and I just like to congratulate both the speakers for bringing out very, very different topic. But so far, I'll just like to address a bit of clarity on, ma'am, what you have talked about. The self-restraint of judges vis-a-vis media. Something very close to our heart, something which, I won't use the word addictive, because I myself am a very media-savvy guy, but I'll say it's way of life. I'll just like to downplay the word called addiction with media, with way of life. We grew up when we used to respect our parents, and the parents would, whatever the parents would tell us, we would just follow. Now, as we are entering a different phase of our life, we have to listen to our children if we want respect. We don't guide them anymore, we have to listen. That's just a shift. In a nutshell, ma'am, I just wanted to put a bit of perspective and a clarity that you talked about subjectivity of judges. I just like to get some clarification on holding the carrot from the other end, this objectivity. Subjectivity and objectivity is a blurring area when it comes to social media, when it comes to invasive of media in today's reality. What about, ma'am, have you done any work on that? And I just request, if possible, can you just explore the possibility where the litigant's name, because India is a diverse country, we have judges who come from the same society from which they live. To the element of biasness, I don't think so we can be, I won't use the word bias, the element of subjectivity cannot be cured. Even if you're insulated or even if you live like a life of a hermit, people may not know you, but what about your own personal values, inclinations, which is very part of your own worldview? That could be expressed in a judgment in a form of your own personal values. So in that level, subjectivity cannot be ruled out. My clarity is that, ma'am, can you do a bit of research work on the objectivity part? And a specific suggestions and an area for exploration, maybe you can work on it, or maybe you can throw light, since it was wonderful listening to you, the depth, is that can we do away with, or can we explore, or have you done any research work on making the name of the litigants anonymous? Objectivity. Don't give Mr. X name, his background, his culture. If he is before the court of law, since we are living in the age of media, we are living in the age of live streaming, we have NICs, we have AI, everything is happening. Can we get the name of the litigant anonymous? Some code word. So when the judge sits, even the public perception judge is not aware who the person is, what is his background, what is his culture, what is his religion. He has got a cause, and the cause is legal. Judges will, if I have to claim a competing balance between subjectivity and objectivity, whatever the personal predilections within his or her domain in terms of value will not be the guiding light in terms of deciding a case, because the sole guiding light would be the law and the rule of law. The objectivity of the litigant will become anonymous. In that way, maybe we can strike a balance, and in that way we can scale down public perception as to what is the personal like or dislike of a judge in deciding a case. Just a suggestion, ma'am, in case if we can do research on the subjective part was well articulated. It was a learning experience, and I think so for us from the bar, it's a wonderful experience to know when we have a case to argue, how do we argue it. It's a small request, ma'am, can you just also highlight the objectivity and if there's a way out to strike a balance. Thank you, ma'am.
So I'm guessing that it was not a question. It's like a comment, right?
Some kind of, ma'am, a bit of objective part of it.
No,
where
I'm actually trying to get off
any
social media to get the time for the research.
No, ma'am. Any research work on the objectivity
No,
of
but,
making the litigant anonymous?
No, but using the word X, the letter X, for litigants is now quite common.
Absolutely.
Particularly in POCSO cases, particularly in cases involving custody of children, particularly in habeas corpus cases where the alleged detinue is a vulnerable adult or a vulnerable child or something. Using the letter X instead of mentioning the name, it's now quite accepted, it's quite common. In fact, I think Supreme Court, today morning's report, I read it today morning. I think the judgment must have been delivered, Justice Suryakant, one of the, I think his judgment.
Jagjit Singh's his judgment is there.
Over there, it was,
2022 Supreme Court, yes.
There was a foreign, I read it today morning, there was a foreign judgment passed imposing a travel ban on the child in a habeas corpus, and the Supreme Court said that that travel ban on the child is completely arbitrary and it cannot be acceptable. There was a custody battle. I have not read the whole judgment. I just read it today morning. So over there, the name is X, mentioned as X. The cause title is X, doesn't give away the name of the child.
Ma'am, if you could just clarify, can we expand this in? Have you done any research work? Is there any possibility of exploring to most of the litigations involving sensitive issues?
I have personally not done any research work on this. But it's now, many of the courts do it.
Yeah.
In POCSO matters, for example, many of the courts do it. It's not something new. Many courts do it now.
Thank you, ma'am.
Thank you. Thank you for your comment.
I think we have one here. If you can share the other. Yeah.
Hello. Yes. Good afternoon. Lordship, this is just a question regarding the sixth schedule. Actually, so as you've stated, the sixth schedule is a mini constitution within the constitution. And the district councils have been empowered to legislate on the topic of inheritance of property as well. But if we see the legislation regarding the self-acquired property, the Meghalaya Succession to Self-Acquired Property Khasi Jaintia Special Provision Act, which allows for the disposal of self-acquired property by will. So when we look at this, is it correct to say then that since the power to legislate on inheritance of property is vested with the district council under the sixth schedule, but it is circumscribed to and limited to only codifying what is already there under custom? Because anything that deviates or derogates from custom then would fall out of the purview of their legislative power. And which is the reason why this particular act was passed by the Legislative Assembly and not the District Council. Would that be correct to say?
Hello. Yes, a good question. The thing is that now in certain areas where the District Council has not had legislation, the example I gave you with regard to land transfer. Now, like I said, that they don't have plenary power legislation. They confine specifically to subjects mentioned in paragraph 3. So they have to make laws within paragraph 3. Now, with regard to, you see, inheritance, but because of paragraph 12A, where the lacuna is there, especially self-acquired property, that's why the state stepped in and made the act. And once the state has equal powers or more to legislate on any topic, right? And so once a state made law is there, it is like overpowers the District Council Act. So that now land transfer regulation came in 72 because that land transfer act of the council, you know, it was a non-starter. So those are the things. That is, there are many areas of which is a very interesting question as to what is extent of codification, how it, you know, it's repugnant to like constitutional values. So those things have to really examined minutely while codifying custom, because custom cannot be, like I said, cannot be frozen. Custom has to change also. Bad customers to go, good customers to be retained. Yes.
Question, it's not question. Ma'am has highlighted that we have got, used to YouTube judges. I will say we have got YouTube lawyers also. YouTube lawyers also. And probably because that we are grappling with this phenomena, it is of recent origin. And we have not come to the terms of the amplitude of this entire phenomena. And therefore it will take some time to mature with the social media and contents, that how do we deal with it in our personal life, or in daily life, or in dispensation of justice. So it's not a question, it's my remarks only, that most often than not, we see so many podcasts where the topics are seriously discussed with the senior advocates. That also illuminates us, that also enlightens us. So we are grappling with both positive and negative sides of this YouTube phenomenon. So, but certainly we have to be aloof and we have to cut off from these noise which is taking place in dispensation of justice. Thank you, ma'am.
Anyone else would like to add anything? So I believe all of us are too tired or hungry. Okay. Anyway, so before we end, I would like to express a heartfelt gratitude to our speakers today. It was very detailed on very key topics. Justice, thank you, ma'am. And we believe that your contribution here have given a lot of weight to our program. and there has been a lot of content, and I think the participants will agree with me when I say that we have a lot of key takeaways when we leave this place. And also a word of gratitude to all the participants for your support, presence, and participation, and to everyone involved in making this program possible. So we've come to the end of this program. So before we leave, can you join us for lunch?